Picture this. You're standing in a courtroom, accused of a serious crime. The judge looks down at you. The prosecutor is ready to make their case, and you're all alone. You ask for a lawyer, but the judge says, no, you can't have one. Why? Because you can't afford to pay for one. You have to defend yourself. Sounds like a nightmare, right? Well, this was the reality for a man named Clarence Earl Gideon back in 1961, and his incredible fight from a prison cell would go on to change the American justice system forever. Today, we're diving deep into one of the most important legal battles in U.S. history. Gideon versus Wainwright. This isn't just a story about a court case. It's a story about fairness, determination, and how one person can challenge the entire system and win. It's a case that fundamentally redefined what a fair trial truly means. So, who was Clarence Earl Gideon? He wasn't a powerful man. He wasn't rich or famous. He was a poor drifter, someone who had seen his share of hardship and had a history of nonviolent crimes. In June 1961, a pool hall in Panama City, Florida, was broken into. Some change was stolen from a cigarette machine and a jukebox. A witness claimed they saw Gideon inside the pool hall early that morning. Vasudontis Gideon was arrested and charged with breaking and entering with the intent to commit a misdemeanor of felony in Florida. When Gideon appeared in court, he was without a lawyer. He was also without money. He stood before the judge and made a simple, direct request. Your Honor, I request this court to appoint counsel to represent me in this trial. It seemed like a reasonable request. But the judge, Robert McCrary Jr., denied it. He explained, Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case, under the laws of the state of Florida. The only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. A capital offense meant a crime punishable by death. Gideon's charge, while serious, was not that. Gideon was stunned. He replied, The United States Supreme Court says I am entitled to be represented by counsel. The judge disagreed, and the trial proceeded. Gideon was forced to represent himself. Imagine that. He had to make his own opening statement, cross-examine the prosecution's witnesses, and decide whether to testify himself. He tried his best, but he was no lawyer. He didn't know the rules of evidence, how to object, or how to properly challenge the testimony against him. The prosecutor, on the other hand, was a trained professional. It was an uneven fight from the start. Unsurprisingly, the jury found Gideon guilty. He was sentenced to 5 years in state prison. This is where the story could have ended. Another poor man, lost in the system. But Clarence Gideon refused to accept his fate. From his prison cell, armed with only a pencil and prison stationery, he began to study the law in the prison library. He believed with every fiber of his being that his conviction was unjust because he didn't have a lawyer. He handwrote a petition, in pencil, to the highest court in the land, the United States Supreme Court. This type of petition, filed by a poor person, is known as in forma pauperis. His petition was a simple, heartfelt plea. He argued that his Sixth Amendment right had been violated. The Sixth Amendment to the U.S. Constitution states that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. Now, for a long time, this was understood to apply only to federal courts. A previous Supreme Court case from 1942, called Betts v. Brady, had ruled that in state courts, the right to a lawyer was not fundamental. A state only had to provide one under special circumstances, like if the defendant was illiterate or the case was unusually complex. Gideon's case wasn't seen as having those special circumstances. So, Gideon was directly challenging a major precedent. He's asking the Supreme Court to reconsider its own past ruling. This was a long shot, to say the least. Thousands of these petitions flood the Supreme Court every year, and very, very few are ever heard. But there was something about Gideon's simple, powerful argument that caught the justices' attention. They saw the fundamental question at the heart of his case. Can a poor person truly get a fair trial in any criminal case without the help of a lawyer? The court agreed to hear his case. Once the Supreme Court takes a case, the game changes. Gideon was no longer just a prisoner scribbling on paper. The court appointed him one of the best lawyers in Washington, D.C., Abe Fortas, who would later become a Supreme Court justice himself. The state of Florida, in turn, put forward its top lawyers to defend its position, led by a young assistant attorney general named Bruce Jacob. The oral arguments took place in January 1963. The central question was clear. Should the court overturn Betts v. Brady? Fortas argued passionately that you can't have a fair trial without a lawyer. He painted a picture of an ordinary person, unfamiliar with the law's complexities, facing the full power of a state prosecutor. He argued that the assistance of counsel is not a luxury. It is a necessity. Justice, he said, cannot depend on how much money a person has. The rich can hire the best lawyers, while the poor are left to fend for themselves. This was an equal justice under the law. On the other side, Florida's attorney argued that the states should have the right to decide for themselves when to provide lawyers. He warned that forcing states to provide counsel in every felony case would be a huge financial burden and would disrupt their justice systems. Interestingly, 22 states actually sided with Gideon, filing briefs in his support and arguing that providing lawyers for the poor was the right thing to do and was manageable. The Supreme Court justices wrestled with this. They understood the immense implications of their decision. Was the right to a lawyer so fundamental, so essential to justice, that it should apply to every state in every serious criminal case? On March 18, 1963, the Supreme Court delivered its decision. It was unanimous. In a 9-0 ruling, the court sided with Clarence Gideon. They explicitly overturned their previous decision in Betts v. Brady. Justice Hugo Black, who had dissented in the original Betts case 21 years earlier, wrote the majority opinion. It's one of the most famous and eloquent opinions in the court's history. Justice Black wrote that reason and reflection require us to recognize that in our adversary system of criminal, just as any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. He went on to say that the government spends vast sums of money to hire prosecutors to charge people with crimes. It's not fair to then expect the accused, especially if they're poor and uneducated, to face those trained prosecutors alone. He famously concluded, "That's an obvious truth." The ruling in Gideon v. Wainwright was a landmark. It established that the Sixth Amendment's guarantee of a right to counsel was a fundamental right, essential for a fair trial, and that it applied to the states through the 14th Amendment's Due Process Clause. From that day forward, every state in the country was required to provide a lawyer to any criminal defendant who could not afford one. This led to the creation of public defender systems across the United States. But what about Clarence Gideon himself? The Supreme Court essay ruling, didn't he set him free? It meant he was entitled to a new trial, this time with a lawyer. He was sent back to Florida for that second trial. The court appointed him a skilled local defense attorney, Dobley and Fred Turner. Turner did what Gideon couldn't. He conducted a thorough investigation. He discredited the prosecution's key witness, showing it was likely the real lookout for the burglary. He demonstrated to the jury that Gideon couldn't possibly have carried out the crime as described. After just 1 hour of deliberation, the jury came back with a verdict: not guilty. Clarence Gideon was finally a free man. He had not only won his own freedom, but he had also secured a fundamental right for millions of Americans to come. His case stands as a powerful testament to the idea that justice should be equal for all, not just for those who can afford it. It ensures that when a person's liberty is at stake, they will have a trained legal professional by their side to navigate the complex and often intimidating legal system. The Gideon decision transformed American criminal justice and remains one of the cornerstones of our legal rights today. The story of Gideon v. Wainwright is a powerful reminder that the principles of fairness and equality are worth fighting for, even from a prison cell with just a pencil and a piece of paper. It shows that one person's determination can truly change the world. Thanks so much for watching. If you found this story as inspiring as I do, make sure to hit that like button and subscribe to the channel. We uncover more stories like this one, where pivotal moments in legal history have reshaped our world and our understanding of freedom and justice. Drop a comment below and let me know what you think, and I'll see you in the next video.